interference with the plaintiff's prospective business advantage resulting in damage. Malice, again, means I had some purpose other than to make a profit myself. Probably I was out just to hurt you. Interference means I've done something to prevent you from receiving this profit that you hoped to get. Prospective business advantage is exactly that, a hope of profit. And that's the third element. It may be, for example, that I talked your Aunt Tilly into cutting you out of her will. Or it may be that I went around telling people that they shouldn't do business with you because you were teetering on the edge of bankruptcy. Or it may be that I told people that your product wasn't as good as mine. If I did it for malicious purposes, I may be liable for any actual damage that result from my interference with prospective business advantage. Another area of tort law that you're going to be discussing, or that you have discussed in your torts class, is the area known as nuisance. And Dean Prosser said that this area of the law is surrounded by an impenetrable jungle. I don't really think it's impenetrable. I'm not even sure it's a jungle, but if it is, we're going to do our best to defoliate it for you right now. I think the reason that so many people find the law of nuisance confusing is that the word nuisance, unlike all the other tort names that we use, the word nuisance doesn't tell us what the defendant did. It doesn't even tell us what the plaintiff claims the defendant did. The word nuisance instead tells us what the plaintiff claims happened to the plaintiff. The word nuisance describes the kind of damage which the plaintiff claims to have sustained. Because a nuisance, and actually there are two different kinds of nuisance, and both of them are really descriptions of the kind of damage sustained. A nuisance is a tort which interferes with a certain right. Public nuisance is a tort which interferes with some right of the general public. And private nuisance is a tort which interferes with the plaintiff's right to use and enjoy real property. What tort? Well, almost any tort. Actually, a nuisance can be defined as any liability-forming conduct which proximately causes an invasion of, if it's public nuisance, a right of the general public. If it's private nuisance, plaintiff's right to use and enjoy realty. So first, it's going to be necessary to show that the defendant did something which was liability forming, that the defendant's conduct provides a basis of liability. Well, you know, we only have a limited number of bases of liability. One is intent. The basis of liability requirement could be satisfied by showing in a public nuisance case that defendant desired or knew to a substantial degree of certainty that his conduct would invade some right of the general public, or in a private nuisance case that the defendant desired or knew to a substantial degree of certainty that her conduct would interfere with the plaintiff's right to use and enjoy realty. Or negligence could be the basis of nuisance liability. An invasion of some right of the general public in a public nuisance case, or an invasion of the plaintiff's right to use and enjoy realty in a private nuisance case, resulted from the defendant's breach of the duty of reasonable care. Or nuisance could result from aggravated negligence. The public right was invaded, or the plaintiff's right to use and enjoy realty was invaded because the defendant willfully disregarded an obvious risk with a high probability of harm. Or nuisance could be based on strict liability. The defendant's engaging in an ultra-hazardous activity, for example, may have invaded some public right, or the defendant's keeping a pet lion in a residential neighborhood may have invaded a neighbor's right to use and enjoy realty. So any basis of liability at all can work for the law of nuisance, so long as the defendant's conduct in a public nuisance case invades a public right, in a private nuisance case invades the plaintiff's right to use and enjoy realty. Let's talk about public nuisance for a moment. In a public nuisance case, the public is the plaintiff. The public's right has been invaded. The public is the plaintiff, and the public is the one who sues, usually through the public attorney, which might be the county attorney or the state's attorney or the public prosecutor or the U.S. attorney even, depending upon what part of the public is suing. And most of the time, we will not be getting involved in public nuisance cases when the lawsuit is brought on behalf of the public. What happens then is that the public sues through its public attorney, and if it collects damages, the damages go into the public fund. And that's all. Everybody gets the benefit of it that way. However, when a public nuisance results in harm to an individual plaintiff, which is different from the harm sustained by the rest of the public, then it's possible for that individual plaintiff to bring a private action for public nuisance. That's not the same thing as private nuisance. We're going to talk about that in a moment. A private action for public nuisance. When the plaintiff has sustained harm which is different in kind, not just in degree, different in kind from the harm sustained by the general public. Now, sometimes it's hard to tell if the difference was a difference in kind or a difference in degree. You may read a case about somebody who polluted the bay, Casco Bay, I think, and the fishermen who usually worked the bay attempted to sue on a public nuisance theory. And the defendant said, look, I polluted the bay and that damaged the general public because nobody could enjoy the bay. Nobody could fish in the bay. So the defendant said the plaintiff's harm is not different from the harm sustained by the rest of the public, and the plaintiff should not have a right to sue for public nuisance. But the court said that while the rest of the public fishes the bay for pleasure, the plaintiffs fish the bay commercially, fish the bay for business. So the court said that made the harm they sustained different from the harm sustained by the rest of the public, and the plaintiffs, the fishermen, were allowed to sue for public nuisance. But I hope you realize when you read that case that a different court could have come to a different conclusion. Sometimes it's a real tight question about whether the difference is a difference in kind or a difference in degree. I'll offer you this rule that you can use when you're trying to make that decision. If the harm sustained by the plaintiff is so different from the harm sustained by the general public that when the public prosecutor sued on behalf of the public could not have collected for that special harm sustained by the plaintiff, then it's different enough to allow the plaintiff to sue privately for public nuisance. Now let's talk about private nuisance, which really is a different area of tort law than public nuisance. Private nuisance is a tort that interferes with the plaintiff's right to use and enjoy realty. So the plaintiff has to be someone who has an interest in the realty, a possessory interest in the realty, a present or future possessory interest in the realty. Now, you're going to take a course in real property, and after you've taken that course, you'll be in a much better position to know who does not have a present or future possessory interest in realty. So for now, let's just say an owner of the realty or a tenant on the realty would have a present or future possessory interest in the realty and might be entitled to sue for private nuisance the defendant whose tort interfered with the plaintiff's right to use and enjoy that realty. The second thing to remember is that private nuisance requires a substantial invasion of right. This is one of those cases where the old proverb, de minimis non curat lex, which means the law does not concern itself with trifles, applies. If the interference with the plaintiff's right was minimal or trivial, the law will not regard it as a nuisance. For example, every day at noon, the factory on the other side of town cleans out its machines and puffs for one moment a bad smell into the air, and then the bad smell goes away in a moment. And all the plaintiff would really have to do is close his window every day at noon